Positive law is law actually and specifically adopted by a proper authority for the government of an organized juror society. Proper authority is the operative word here, okay? And most of the law that you will see has not been adopted by proper authority, and we're going to go through that. This is taken from the Office of Law Revision Council. That's from the U.S. House of Representatives. And notice this highlighted stuff here. It says certain titles of the code have been enacted into positive law. The text of those titles is legal evidence of the laws contained in those titles, okay? The other titles of the code are, and here's some words again that we need to keep in mind, prima facie evidence of the laws of the United States, of the laws contained in those titles. The following titles have been enacted into positive law, and it lists all the positive law titles. But we're not going to talk about those. We're going to go and talk about the ones that are not positive law. These are the list of non-positive law titles. And look at them. Title 6, domestic security. Okay. Now the Border Patrol. Okay. They operate under Title 6 and Title 8. Okay. Neither one of those is positive law, and they go and violate your rights under the color of law every day. They violated my rights so many times I can't count, and so I'm getting ready to file a lawsuit against them. But anyways, and it'll be one of I've done at least one other one, and we're going to party again. Again, you have to think of it this way: if they violate your rights and you don't say something, then you're at least partially responsible when they violate the next guy's rights. So I have to. Anyways, these are all non-positive law titles: banking, trade and commerce, customs and duties, education, foreign relations. I mean, why would the people have anything to do with any of this stuff anyways? There's no reason for them to be positive law. Indians, internal revenue. Do you know the Internal Revenue Code is not positive law? It has nothing to do with we the people. So then, and we'll go into this, it's actually a contract. And if they're sending you stuff, then they either have you in a contract or are trying to get you in a contract. So that's the issue. Anyways, all of these titles are not positive law. So therefore, they're not passed with legitimate authority, and they mean absolutely nothing to we the people. Color. Some more words. Okay, color. An appearance, a semblance, or a simulacrum as distinguished from that which is real. A prima facie or apparent right. Here's that word again. Prima facie. Remember, they said non-positive law is prima facie evidence of the United States. Okay? We're going to go into that prima facie a little bit more. Okay? But so color is a prima facie or apparent right. And notice this word appearance and apparent, hence a deceptive appearance. A plausible assumed exterior concealing a lack of reality, a disguise or a pretext. Okay, that's all color. Colorable, that which is in appearance only and not in reality what it purports to be, hence it's counterfeit, feigned, having the appearance of truth. It's a lie. Color of law means the appearance or semblance without the substance of legal right. Misuse of power possessed by virtue of state law and made possible only because the wrongdoer is clothed with authority is action taken under color of law. I mean, that's exactly what they do all the time, and it's because you don't know who you are and you're letting them get away with it. Prima facie, that's one of these words that we're talking about. Prima facie, at first sight, on the first appearance. Remember that word appearance? That's here again. So far as can be judged from the first disclosure, presumably, okay, that's another word you need to be thinking about. A fact presumed to be true unless disproved by some evidence to the contrary, okay? And so, and this is one of the things that we're going to be going through in the paid part of the presentation is presumptions and how to defeat their presumptions and why they are taking presumptions and what to do about it. But so right now the important thing is that prima facie is, this is the definition of prima facie, okay? In other words, prima facie evidence is based on presumptions and it can be defeated, okay? But you have to have your ducks in a row or they are going to just walk all over you. There's a maxim of law called the justum generis. and it says it's basically of the same kind, used to interpret loosely written statutes where a law lists specific classes of persons or things and then refers to them in general. The general statements only apply to the same kind of persons or things specifically listed. Example, if a law refers to automobiles, trucks, tractors, motorcycles, and other motor-powered vehicles, then vehicles would not include airplanes, since the list was land-based transportation. So, this is in the definition section of the Internal Revenue Code. They know that's not positive law, and they're very careful to make sure that their definition section is correct. So think about this. The term person shall be construed to mean and include an individual, trust, estate, a partnership, association, company, or corporation. Okay? Based on ejusdem generis, think about this. What do you think an individual is? And I'll give you a couple of minutes to think about it. And now I'll tell you. An individual is a type of a fictitious entity. Based on ejusdem generis, because a trust, estate, partnership, association, company, or corporation, those are all fictitious entities. So then an individual is also a fictitious entity. And in fact, when I went to the U.S. Supreme Court, that was what I said, is that an individual or a person is a Title 15 United States Code, Section 44, unincorporated corporation. If you look that thing up, it'll say that an unincorporated corporation can have a board of directors, and it may not. It can have executive officers, and it may not. And gee, so that's wide open, and that's what a person is. That's what a U.S. citizen is. Actually, they know that a U.S. citizen is a fictitious entity, and they admitted it in my case. They waived their right to respond. That admits everything, and they admitted it in my case. Include some more definitions. Include, or the participial form thereof, is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. Okay? In other words, the word include is restrictive. Okay? It doesn't mean that there's stuff there that they're not listing. Okay? So let's go back to this other one. Oh, right here. The word person shall be construed to mean and include. They put that in there so that, you know, people that don't understand the law think, well, gee, you know, I'm an individual, but then they also think, well, you know, maybe I'm not an individual, but I think that I'm in that list. Because that list includes everything. Yeah. Well, I'm here to tell you that it doesn't. Here's another maxim of law. Expressio unius exclusio alterius. A canon of construction holding that to express or include one thing implies the exclusion of the other. Or of the alternative, for example, the rule of each citizen is entitled to vote implies that non-citizens are not entitled to vote. It's that simple. And so, remember, if they don't list it there, then it's not there. But the subpoena, now there's two kinds of court citations. And this is one. This is an actual citation, and sometimes I use a summary, okay? And the difference will be is the citation will be in quotation marks, and the summary will not. This is the citation, and sometimes I like to use the summary because somebody went and come up with a way of explaining it that I think is way better. But this is the citation. It says, but the subpoena is in the form of an official command, and even though improvidently issued, it has some coercive tendency, either because of ignorance of their rights on the part of those whom it purports to command, or their natural respect for what appears to be an official command, or because of their reluctance to test the subpoena's validity by litigation. Okay, that's what the Supreme Court said. Now, this is much better in my opinion because I think it really spells it out better. It says, because of their respect for what appears to be a law, many people are cunningly coerced into waiving their rights due to ignorance. And I think that's way better. I like that better. So you'll see that. I'll put that in some of my paperwork. A distinction was taken at the bar. Okay, this is the quote. A distinction was taken at the bar between the state and the people of the state. It is a distinction I'm not capable of comprehending. And then it actually, the quote is, if you notice there's 3 or 4 dots after that, that's because it goes into a 2-page diatribe about why he's not capable of comprehending that.